So, professors, I have two cases there. Now, let me ask questions to direct you to probably forming an opinion or judgment on it. So the first one, Kwame tells Akosua, hey, I will sell you my bike for 200. It ends there. In the second scenario, Kwame agrees to sell his bike to Akosua, and Akosua in turn also agrees to pay with a specific date, 1st January 2025. Now, my question is, in the first case, if Kwame does not sell the bike to Akosua, can Akosua sue Kwame? And would she be, would the court rule in Akosua's favor or otherwise? Same in the second scenario. If Akosua sues Kwame, okay, for failing to sell the bike. Yes, who starts the judgment? Prof. Bridget, I don't know if you are still with us. You can type in the chat though if you are struggling with your microphone. Or maybe you've lost your voice from eating lots of fufu and palm nut soup yesterday. Prof. Bridget, I would love to hear your voice today though. Yeah, Prof. Ethan.
Yes, sir.
Yeah. So in this case, do you think Akosua would have any chance of winning the case in both scenario 1 and scenario 2 if she were to sue Kwame for failing to sell the bike to her?
Please, can you come again?
Yeah. So if you check the two cases on the screen, right? If Akosua should go to the court, probably because Kwame failed to sell the bike, okay, do you think she would win?
Yeah,
Okay, what would be the reasons or the basis for which she would win this case?
because it seems like he has already told her about what he's going to do. And
Okay,
then Akosia has made up her mind that, oh, she'll bring the money, and then she's waiting for Kwame to bring the his bike so that she can pay for it.
okay. So you are speaking to case 2 or case 1 or both of them?
And case one.
Case 1, okay. Thank you, Prof. Ethan, for that. Any other? Yes, Selikem. Let me hear you, Judge Selikem.
So please, I think in phase one, there is no contract because there has to be two or more parties, and Akosia would have to agree. But in case one, there was no agreement. She was silent if we are not considering the case two. But when she agrees in case two, then I think that's when it becomes a contract and she can sue him.
Okay, interesting. Um, who else is that? That was Selikem, right? But I think somebody's hand was up too. Princess, let me tell you, for this topic, you are going to do more of the talking because you have to give me your perspective of the judgment before we dig into what actually transpired. Okay. So we are going to be seeing lots of cases, and I'm going to be asking you about your judgments. So pardon me if you are not interested in law, or better say you don't want to see yourself in the seat of a judge. But who knows? Sometimes what you run away from is what you actually become, right? So let's feel free to share opinions. It's an opinion, so there's nothing like it's wrong or right. You have your reasons for making those statements or those opinions. Okay. Well, I think Selikem said something that in the first instance, you don't see a clear agreement or consensus being built by the two people, Kwame and Akosua. I think I tend to agree with her. But in the second case, there's actually an agreement because Kwame agrees to sell, Ikua agrees to buy and pay on a specific date. Okay. I want to hear one more, Professor, before we move on. Now, why am I showing you this case? I'm showing you this case to let you appreciate that when you are confronted with issues, you have to dig in to pick the elements or the facts in the case. Okay. And so, like we have rightly done, in the first case, we don't seem to pick out the elements in there because for an agreement to be a contract, it should be enforceable, right, by law. In the first scenario, if you go to court, what are you actually going to enforce? Because Kwame says, hey, I'll sell you my bike. It ends there. So what are you actually going to enforce in the law, in the court of law? You remember the other definition says that the two or more parties should have made a mutual exchange of promise. But if you look at the case one, Kwame is making a promise. Akosua hasn't made any promise in that regard because Akosua hasn't said anything. It's just Kwame saying, hey, I'll sell you my bike, 200. Okay. And then lastly, it says that each party agrees to do or not to do something in exchange for a benefit. So again, what did Akosua agree to do or not to do in the first case? There's none. But all these things are present in the second case, right? There was an agreement which is binding and can be enforced at law because I say I will sell the bike to you at 200. If you don't pay the 200, I can take you to court to pay the 200, right? If you don't sell the bike, I can take you to court to sell the bike because you agreed to sell it. Now, in the second definition, both parties make a promise, okay, to give something of value to the other. So here, Kwame is giving his bike. Ekwa is also going to make payment in money. So the point is that you always have to fish out certain elements before you can determine whether this is a contract or not. Now, these elements are very important. However, before we get to these elements, it's also important to say that sometimes people make certain statements, okay, like the one Kwame just made. Hey, I will sell you my bike. It's, for example, your parent telling you, hey, I'll give you 100 cedis. Right? Does that make it binding? Can you sue your father if he doesn't give you the 100 cedis? Because it could have been just a promise. I promise to give you 100 cedis. So it's also important to know the difference between a contract and a promise. Now, what is a contract? We have seen that. A legally binding agreement between two parties, okay, which can be enforced by law. What of a promise? A promise is a voluntary declaration or assurance made by one party to another, committing to perform a specific action, fulfill an obligation, or refrain from doing something. So it is often based on trust, moral obligation, or personal integrity. So a promise in itself cannot be seen as a contract on a face value. However, it can become a contract if it has some necessary element. So again, we go back to the point of you fishing out the necessary element. So before you can think about suing somebody or, enforcing some agreement, those elements should be present. If those elements are not present, then that particular thing could be seen as a mere promise. So what are these elements that can help you determine that, yes, you would have a case if you should take this to court to enforce? Now, before we look at the elements, I'm going to play around the cases again. So look at this. This is a popular case in law, right? It's a case between Carlyle and Carbolic Smoke Ball Company. Okay. Now, one of you should read the case for us. And then again, we are going to express our judgment on this. But this time I'll tell you the ruling. Okay. So who is doing the reading? Prof. Bridget, can you read for us? Prof. Bridget. Bridget, if I'm worrying you, you can take me to court, okay? But I don't know if there's any issue, you can prompt me, okay, so that I don't worry you that much. But can you read for us? I'm beginning to think maybe she's struggling with her microphone or something. Okay, Augustine, is your surroundings okay for you to read for us? If yes, please do for us.
Sir, please, I'm reading. Where should I read?
Yes, what is on the screen? The case between Carlyle and Carbolic. So Carlyle versus Carbolic Smoke Ball.
Okay. So Carlyle versus Carbolic Smoke Ball Company. It's 1893. The Carbolic Smoke Ball Company produced a medicinal device and advertised that they would pay €100 to anyone who used their products as directed, and still contracted the flu. To show their seniority, they deposited €1,000 in the bank. Mrs.
Okay, I think I would continue for guessing his. Well, so I've been prompted that Bridget is having microphone issues, so that's why. So well noted, Bridget. So this was a case between a lady, or let me say a Mrs. And now normally the cases are stated this way: Carlyle versus Carbolic Smoke Ball. So the vein is versus, right? So this company, produced a medicinal device that was to fight flu. I hope you all know flu, right? Now they advertise that they will pay £100, okay, to anyone who used the product as they have directed and still contracted the flu. Now, they went ahead to make a deposit into a bank account to show that, yes, they will make the payment if anybody should report back to them that they used the thing and they are still, having the flu. Now, this Mrs. saw the advertisement, purchased the device, used it according to instructions. She still got the flu. And so she sued the business. She sued the company to claim the reward. If you were sitting in the seat of the judge, what would be your opinion? Would you grant Mrs. Carlyle the reward? And why? Who will be my first judge? So you can look, for example, in Ghana, where these medicine companies, right? Tabia. Sorry to use some of the example, but Tabia, whatever, Tabia, Mesha, Masada, and all these creams that they do lots of advertisement. This is a typical one, right? So what will be your judgment? So Bright, let me hear you on this, Prof. Bright. The woman purchased the device, used it as it was directed by the company, yet still she contracted the illness, that's the flu. The reason why she's suing the company for the reward. Would you rule in favor of her or against her, and why? We want to know your reasons.
Sir, please. Sir, please, I'll rule in favor of her.
Why?
Sir, please, because she has evidence that she used the medicine, and when she used it, it did not work. She still has the sickness, and the company for the medicine agreed that anyone who uses the medicine and still gets the flu will be rewarded 100. This one.
Okay.
100. Yes. So if she sues the company for their money, then the company must pay.
Okay. Yes. I think I have Jason in the house. I don't know if he follows the discussion, but let me hear from Josephine and Portia.
Okay, sir. Sir, please. So first off, the woman has every right to sue the business for the money. But on the other hand, the company also didn't have any agreement with anyone. It was like a promise. So if they later come on and say they are not going to give any money to anyone, I don't think the woman has to sue the business, because it wasn't an agreement.
Well,
yes, it was
I think interesting. I think Bright has a counter argument. Bright, let's hear you.
Please, I disagree, because the company came out to say that anyone, like they said it, anyone who uses the medicine and does not, get the cure, like, who get the $100 or the pounds.
Okay.
And now you're telling me a promise. How can you say a promise? You came to the social media, like everyone, like me, you are telling me it's a promise.
Okay. Thank you there. Portia, let's hear you. Augustine, I'll come to you after Portia.
Say, please, please, I think she's right for doing that, because the business themselves said they will pay anyone who is their product as directed, and she did that as well. So since she has done it already, she needs to get the money they promised to give to the person who used their product.
Okay. Any other thoughts from Selikem, Janelle, Prof. Janelle? You haven't made any judgment yet, Prof. Janelle. Yes, Selikem.
So please, for me, I would rule in favor of Mrs. Khalil.
Okay.
Because the advertisement, like, it promised a reward to her, and I think for the company to go as far as depositing the £1,000, it means they were serious about it. So if Mrs. Khalil accepted to, perform the conditions in the advertisement, and she still didn't get that desired, results, I think it's right for her to sue them. Sorry. Yeah, so please, that's my opinion.
Okay, so I think the only the different judgment is from Bright, and he still wants to defend. Bright, let's hear you.
I wanted to say something that recently this thing happened when we were contesting for the NSMQ, and it was Butchie, Ogasco, and was, and a man was applied for that if the portray boy wins for them, we give him a 17 Pro Max iPhone.
Okay.
And when the man gave it to him, how can he tell me it was a promise? You know, me.
Okay.
The Mrs. Khalil Siu, what do you call the company must pay, because they came out to say that I'll give you 100 pounds if you use the medicine and does not work.
Okay. So yes, I think it's Josephine who was rather having a different judgment, right? Seeking to look at the other side from the company's perspective, that there was no specific agreement between Ms. Khalil and the company. Ms. Khalil did not reach out that, hey, indeed, I'm going to use your medicine, and if it fails, I'll come for the reward. I think that was the viewpoint Josephine was trying to put across. Yes, though valid. All these things were argued out in courts, frankly. Lawyers of both the plaintiff and the defendant. Now, let me be quick to tell you that if you have a case, the person who is doing the reports or who goes to the court first to sue becomes the plaintiff, okay? And then the person who has been summoned becomes the defendant. So note this thing. So Khalil here is the plaintiff and the company is the defendant. Of course, their lawyers would argue that, hey, because of ABC, but let's look at it. Yes, the company made a promise that if you use the medicine and it doesn't work, we are going to pay this amount to you. Now, this is more or less like a conditional promise. Compare this to the earlier promise made by Kwame. Hey, I will sell you my bag. You see, this is vague. There's no condition attached. If Kwame had gone ahead to say, I will sell you my bag if you pay me 200 Ghana cedis, and then Akosua goes on to pay the 200 cedis, then that promise becomes a binding one. So that is to say that a promise, okay, can become a contract if it has the necessary element. Okay, and one of them, as you have all seen in this case, is that yes, the company even went ahead to deposit money in the bank account. Committing to, seriousness that, hey, yes, indeed, we are ready. If you use and it fails, we are going to pay the money. So if you make promises that have certain element that could bind you, then that promise is no more a mere promise, but a contract. So let's look at the ruling of the courts. The court stated that, of course, they ruled in favor of Ms. Khalil, determining the advertisement was a serious, legally binding offer of a unilateral contract, which is a type of contract we look at, where one party makes a promise in exchange for the other party's performance of an act. The court reasoned that, so these were the reasons that the court gave, that the deposit of the £1,000 demonstrated a genuine intention to be bound by the promise, not just a mere sales path. Now, Ms. Khalil provided sufficient consideration, okay, something of value for the promise. Yes, Augustine, I'll come to you. By purchasing and using the smoke ball as requested, which was detrimental to her and a benefit to the company. So you see, let's go back to the definition of contract, and then maybe you'd appreciate, which says that each party agrees to do or not to do something in exchange for a benefit. And again, there is a mutual exchange of promise to perform an act. So look at what the woman did. The woman went to purchase the medicinal device for which the company will benefit, because then they'll get the money from the woman. So the company is benefiting, right? And the woman is also going to suffer, because if she uses the medicine and it doesn't go well, she suffers, something valuable. Now, the other bit the court brought to bear was that acceptance of the offer occurred when Ms. Khalil performed the condition, as in using the smoke ball as directed, without needing formal communication of acceptance. So this is why the court ruled for the woman, because one, the company showed a genuine intention to be bound by the promise they made by going ahead to make a deposit into a bank account. Again, even though it was an advert and Mrs. Carroll could have been any other person who was watching the advert, in as much as the lady went ahead to purchase, so she exchanged something of value with the company. The company got her money and she also got the medicinal device. And she went ahead to use it as directed by the company. Well, the company cannot say, well, we didn't have any, written agreement or whatsoever. In as much as you accepted her money and gave her the product, that is even enough basis for Ms. Carlo to sue for the reward. Okay. Now, having read this case, okay, Augustine, let me hear you before I move on. Augustine Akoli, let's hear you.
Sir, please, I think I go for the company.
You would go for the company?
Yes, sir.
Why?
Sir, please, question number one, it is an advert. They said that they said they would pay 1,000 they'll pay 1,000 euros for anybody who does it. So number one,
pounds, right? Pounds.
Pounds for anyone. So it's the thing is for the general public, and I'm a general public.
Mm-hmm.
So the thing is between 2 or more people, and like it's for the general public. That's
Yeah.
number one. And number two is that there was no vivid proof that Miss Carl,
yeah.
And there was no vivid proof, Miss Carl, and that she did it like us. This one, there was no vivid proof. Maybe she's lying. Who knows? So there was no vivid proof that she went to the hospital.
Sorry to cut you, but you think the court will not ask for that? Well, the case says that she used it according to the instructions. So it means that she was able to prove. Probably she was taking videos as and when she was using it. So she proved that, yes, she used it according to their instructions. Okay, so there was that proof that she used it according to their instructions. So, well...
I'm not talking...
So
I'm talking about like the reports, like from the hospital that she has used the medicine. She has used the medicine, and this is there was no proof, like there was no proof of that.
Okay, lawyer Augustine, your point well made. Bright wants to say something.
Augustine, please. That's why Sir said when you go to the court will ask you for evidence, for proof. So they use the proof to judge. Do you understand?
If I'm right, I can imagine you in a court too. You come across as an aggressive lawyer. Anyway, so I think you all appreciate that. First of all, you see, we watch a lot of adverts on TV, but why is it that we cannot sue them for certain things? Because some of the adverts are such that there's no element that makes it binding on the company. I think you watch adverts from what do you call it? Some of these, I want to remember one where they say, if you use it to cook, your food will be sweet. Like this tomato paste and those things. Now, if you use it to cook and your food does not taste sweet, can you go and sue the company? You see, in this circumstance, it will be hard for you to win because the company just made a a promise that if you use their tomatoes, your food will be sweet. They didn't further commit to anything. If the company goes ahead to say, if you use the tomatoes and your food does not taste this way, we are going to do this, then you begin to realize that the company is beginning to bind itself, and you can enforce that in the law or at the law court, right? But most of the adverts we see are not binding because they are mere promises. And there are no elements that can be used to bind the companies. Augustine, you still have a counter argument. Let's hear you.
It's about this one, the thing that there's no, like, the company hasn't that, yes. But also, like, I thought the consumer also has some rights.
Mm-hmm.
Yeah. So if you come, like, make an advert that you said that the food, what am I saying? You said, made an advert that if you use this one, if you this one, your food should be sweet and all the, like, those type of stuff. Yes.
Mm-hmm.
And when I did it, people know the same, because I also have my rights, like the right to head. I also go and testify to the court that, because you said that if you do this one, your food should be sweet. If the food is not sweet, then I can also do
But
back to my
you
money.
agree that that's a vague promise. In fact, let me even go into the cosmetic industry. You find a lot of adverts where, you see some beautiful ladies with fresh skin, and they will tell you that, hey, if you use this, the ladies can attest to this, right? If you use this, what they call pomade, your skin will be smooth. It will be light and all that. The issue is when you go and buy and use and doesn't, you don't get those things. Do you sue the company? Yes, you can go and sue, but trust me, you'll not win because the adverts did not provide any element that made it so binding on the company. Unless probably in the adverts, there is a statement that if you use and your skin does not turn as they are saying, then you can go and claim your money. In that case, there's a binding, term that you can enforce at the court. Because then if you use the pomade and your skin is not changing like they are saying, then you can go and claim that, hey, you said if I use and it doesn't turn this way, I can come and claim my money. So you have to be very careful to be able to identify the elements. And I'm still guiding us to these elements, okay, as we move on. So having looked at this case, the number one element that we'll look at is, for there to be a valid contract, there should be an offer and acceptance. One party should offer and one party should also accept. There should be an offer and acceptance. Now, what is an offer and what is acceptance? I think we'll dig more into what offer and acceptance is with the help of these two cases. Case one between Taylor versus Lied. Forgive me with the names, okay? And then we'll also look at the case between Hyde and Wrench, Hyde versus Wrench. We'll look at these two cases and maybe you can appreciate the first. In fact, it is the basic element you have to see in every contract. There should be an offer and what? Acceptance. So professors, in trying to get you to appreciate what we are discussing, we are looking at contracts, law. Okay, and we said a contract should be a legally binding agreement between two people, which can be enforced under the law. It should also be an agreement where two parties mutually exchange something of value, or an agreement where one promises to do or not to do something to the other party. And one of the key elements of contract is there should be an offer and acceptance. We've also seen the cases where a promise, though might not be a contract, if it has certain elements, it can be seen as a contract. So for example, your father can promise you, hey, Augustine, hey, Portia, hey, Josephine, I'll give you 100 cedis. this cannot be enforced. But if he goes ahead to say, I'll give you 100 cedis if you get 90% in your accounting exams, then this promise is more binding, isn't it? Because you can enforce him to pay the 100 cedis when you get the 80% in the accounting with evidence or proof that, hey, I've gotten the 80% you requested for. So in a way, it is suggesting that when you make a promise with a condition and somebody acts based on that condition, it can be enforced. And some of the cases we have seen points to that point, like the Carbolic Smoke Ball Company, right? Okay, so professors, we have some 15 minutes remaining to end the class. Let's do that. Let's look at the elements of a contract, offer and acceptance, and then maybe we'll look at the second element. In fact, there are a lot of them. Okay, so let's meet in the final session, which is use the first login details. Okay, thank you. So see you for the last 15 minutes.